So very good evening to all the all attendees. Good evening to Justice Abraham Mathew, and good evening to Live Law. See, law of evidence. We have in common law countries, we have an exclusionary rules so far as law of evidence is concerned. James Bradley Thayer, in his preliminary treatise on evidence at common law, said that in English-speaking countries, as well as all common law countries, we should add the word common law countries, we have evolved the large, elaborate, and difficult doctrine of exclusionary rules so far as law of evidence is concerned. Why was this? Why did this happen? We have law of evidence in this fashion in America, in United States of America, in UK, in Australia, in our country, in Burma, in Bangladesh, in Pakistan. See, all these common law countries have this devoted to the determination of what is not evidence according to the evidence law. Now, Simon Baldwin, a professor at Yale University, said that most part, since this was designed fundamentally for jury trial, and jury are easily swayed by stray evidence, and if you pour in a lot of evidence before them which are not relevant, they are likely to come to wrong conclusions. So according to Simon Baldwin, this was the reason why these exclusionary rules came in. But Michael J. Sachs, in his Psychological Foundations of Law of Evidence, has another argument. He says it is lawyers who are proffering evidence. Here they have got lot of control. They'll try to persuade the jury and the judge by bringing in all irrelevant and other stuff which are favorable to their clients, and therefore to control so that the judicial trial is not open-ended. It has to end within a time frame, and that is the reason why we have exclusionary rules. Now, how does trials happen in our common law system of adjudication? See, it is basically through witnesses. If there is circumstantial evidence, it is a witness who comes to the court and says about the circumstances which surround the relevant facts and the fact in issue. And we either believe the witness or disbelieve him based on his faculties of perception, his credibility, and such other matters, and then come to a conclusion whether we can accept what he says or not. It is on that premise the next stage is reached in the judicial trial and finally in adjudication. Now, one of the methods how the faculties of perception is tested, you must have some of you must have seen the movie 12 Angry Men. One of the finest movies really about judicial trial in a common law country, jury discussing the evidence and coming to a conclusion that none of this evidence is relevant or admissible to come to a conclusion that a particular person, that is the accused, had committed the crime. One was regarding the faculty's perception of an eyewitness who was wearing a soda glass. The other was regarding the memory. See, memory is a very interesting thing. See, in the small area of the brain called hippocampus, we have that spatial memory stored there. Now, what happens in a cross-examination fundamentally is that his memory is tested. Of course, inconsistency in the previous statement and the current statements may lead to a conclusion, not always, because human memory is never perfect. Your memory can be altered. Walter Raleigh, he was convicted in England. Abraham Mathew sir is here. I'll just conclude this.
Okay. You may continue.
So the Walter Raleigh was interred in the Tower of London. He was accused of treason, of trying to dislodge King James. And he was tried by the Chief Justice of England, who was then the Chief Prosecutor. And from his tower, when he was undergoing the sentence, awaiting his death sentence, he saw a murder taking place just in front of his house, down below in the street. And then there were 7 witnesses, eyewitnesses to this incident. He found that there were 7 versions to the same incident, including his own. then he was writing his histories. And he said history and fact-finding by courts are in a way similar. And how can we rely on the memory of witnesses who on the base on a recent event are likely to go astray? So these are all the things which we have to understand. Now, so far as witness examination is concerned, in chapter 10 of the law of evidence, so which Abraham Mathew will be taking you to all the subtle nuances of confronting a witness, contradicting a witness. See, law of evidence, see, Stephen says that in the matter of law of evidence, it is experience which gives you the proper insight into the subtle nuances. Abraham Mathew, sir, as you all know, he was joined the judicial service way back in 1988. He continued to become a district judge. He was additional director of training and director of training for a long period in the Kerala Judicial Academy. I had occasion to associate with him. I also later on joined the Judicial Academy as additional director. Then he was a vigilance director, registrar. So we were in the same campus because vigilance registrar's office was also housed in the Judicial Academy. And invariably, it was he who used to assist us in conducting the classes. Without any fail, he would come and address the trainees, and it was very useful for them. And now we have, he, after many years in the High Court of Kerala, he was elevated in 2013. Now he is before us. He will take us through the way in which a judicial trial is to be conducted while examining a witness. And you should understand that in common law trials, why this is, we have these exclusionary rules, we have so many rules, is because the trial should not be open-ended and people should not go astray. We have to end the trial within a time frame with the best available evidence. So I would invite Justice Abraham Mathew to address the attendees. Thank you, sir.
Thank you, my dear friend, Mr. Harindranath. We are late by 10 minutes, I think. I don't know whether I will be able to complete the discussion today because my throat has started giving me some problems. Okay, but I think we can divide it into two, as suggested by Mr. Rashid. So first part we can complete today. The other part we can complete later. Okay, contradictions under the Evidence Act is the topic today. There are 4 sections in the Indian Evidence Act which relate to contradictions. But we are familiar only with 2 sections, actually 145 and 155. Or to say that only one section, that is 145. These 4 sections are sections 145, 153, 155 and 158. But for the present purpose, we are only concerned with sections 145 and 155. They are only relevant for our purpose. So we shall start with the question. Why is section 145? Even in the absence of section 145, whether the party can cross-examine a witness as to his previous statements. If there is such a provision, why section 145 was incorporated or inserted in this act? This is the question we have to find out first. That will always help us understand the section properly. So we know that evidence is classified as follows. One is oral evidence. The second is the documentary evidence. The third is the real evidence or the material evidence or the physical evidence. And the latest one is the electronic evidence, which we can see in section 45 capital A Evidence Act. So there are 4 classes. Oral evidence is given by way of examination of witnesses. No other means to give oral evidence. Examination chief, cross-examination and re-examination are the 3 stages in the examination of a witness. Once a witness is examined in chief, the adverse party has the right to cross-examine that witness. It cannot be denied. This right flows from section 5. Read with sections 3 and 138. The Act recognizes special rights of cross-examination. One of which is contradiction of the witness. It is a special right during the cross-examination. This right, which is available only to a cross-examiner, is created by sections 145 and 155. Thus, the right is not a right of cross-examination. This right is not a right of cross-examination because right of cross-examination is available under section 5, read section 3, the definition of evidence, and section 138. So, right of cross-examination is there, notwithstanding section 145. Even if 145 is not there, then the adverse party has a right to cross-examine the witness. Then why section 145? The right to adduce documentary evidence given by section 5, read with section 3, is regulated by the provisions in the code of procedure or codes of procedure. To admit a document in evidence, it should be both relevant under the provisions from 6 to 55 and admissible. So, unless a document is both relevant and admissible, they cannot be admitted in evidence. It cannot be admitted in evidence. But admissibility may further be affected by the provisions in the codes of procedure and special statutes. The ordinary rule in civil proceedings is that documents should be produced along with pleadings. See, Rule 14 in Order 7, then Rule 1A in Order 8. So, these say that these documents should be produced along with documents. And if they are not produced, it cannot be admitted in evidence. So documents which are not so produced will not be admitted in evidence, even if they are relevant. So it is relevant, but it cannot be admitted because of the provisions in the CPC or CRPC. Then in criminal cases, the documents for the prosecution should be produced along with the complaint or the final report. Of course, in both civil and criminal cases, the document can be admitted later. If it is produced later, the court can permit to produce it. That is an exception only. So, thus, documents which have not been produced in accordance with the provisions of the courts cannot be admitted in evidence. The evidence means cross-examination also. So, even for the purpose of cross-examination, the documents should be produced as provided in the rules in the CPC and the CRPC. Otherwise, even for the purpose of cross-examination, which is part of evidence, documents cannot be admitted in evidence or used for evidence, used as evidence in the case. On the other hand, the provisions relating to use of documents, so the provisions relating to production of documents are seen in the Code of Civil Procedure and the CRPC. But the provision relating to use of documents, as distinguished from production of documents, are made in the Evidence Act. That is the difference mainly. So section 145 of the Evidence Act enables a party to cross-examine a witness as to his previous statement in writing without it being produced in case and even being shown to the witness. See, when the rules in the CPC say that they should be produced along with the pleadings, now section 145 says that for the purpose of section 145, document need not even be produced or need not be even shown to the witness. That is the special right created by section 145 and section 155. So to avoid this conflict, so there is a conflict. To avoid this conflict, a provision has been made in both in CPC, in Order 7 as well as in Order 8, that nothing in this rule, that is sub-rule 1, so rule 1, shall apply the documents produced for cross-examination of witnesses. That is rule 4. Sorry, sub-rule 4. So, to avoid this conflict, such a provision has been made. That is the special nature of a section 145. The ordinary rule is that a document may be used in evidence, that is examination chief, cross-examination, and re-examination opinion, only after it is proved. So only if the document is proved, you can use it, either in the examination chief or the cross-examination or re-examination, whatever. This is reflected in section 136. Also, section 145 is an exception to it. You can use the document first, then subsequently you can prove it. That is why section 145 says that without being proved, so even before it is proved, you can use the statement, the document containing the statement under section 145 for contradiction of the witness or for cross-examination. Thus, after the contradiction is brought out, the party who brought it out examines the person as witness who is competent to prove the document. So it is the other way about. The ordinary case is that you first prove it, then use it. But here under section 145, you use it, then prove it. So to that extent also, section 145 is an exception. Now coming to the opening words of section 145, there is a witness may be cross-examined. See the opening words. A witness may be cross-examined. So the right conferred by the section is available only in cross-examination. This is a special right given to a cross-examiner. A person who conducts examination chief has no such right under section 145. But when permission is granted under section 154, the party who conducts the examination chief also gets the rights which are available only to a cross-examiner. So the right given under section 154 is not to cross-examine the witness in the midst of the examination chief, but to put questions which might be asked in cross-examination. So in the examination, the course of the examination chief, the party who conducts the examination chief, who called the witness, gets the right to put questions which might be asked in cross-examination. That means there are some rights which are available to a cross-examiner. And one of those rights is the right under section 145. And it is not cross-examination, though in many judgments we can say that cross-examination. It is not cross-examination. One party cannot conduct examination chief and cross-examination at the same time. It will continue even after section 145 is invoked, or the rights are conferred under section 154. The examination will continue as examination chief, not as cross-examination. Okay. So, Evidence Act is not the only statute containing rules of evidence. Many other statutes, including CPC and CRPC, contain special rules of evidence. That also we have to bear in mind. See, Order 26 Rule 10 regarding commission, report, admissibility, then 293, 294, etc. In CRPC, there are all rules of evidence. There are many rules of evidence. And the section with which we are concerned is a section 162 CRPC. We shall come to it later. So there is a special rule of evidence in CRPC, which we can see in section 162 with regard to contradiction or use of a previous statement. So, subject to the conditions mentioned in the proviso to section 162, that statement also may be statement recorded under section 161 CRPC, also may be used for contradiction under section 145 Evidence Act. It is specifically mentioned. Then there are other two exceptions. We need not look into it. Section 32, clause 1, then section 27 Evidence Act, for those purposes also that can be used. So we have seen that section 145 creates a special right in favor of the cross-examiner. The right is to use a previous statement of the witness for cross-examination as to the previous statement, provided the statement is in writing. But there are some statutes which prohibit use of the statements at all, previous statements at all. And the classic example is Commission of Inquiry Act. The Commission of Inquiry Act, Section 6 prohibits use of any statement given to the Commission for any purpose. That is settled now, AIR 1988, Supreme Court 1883, Khar Singh, you know all this case, Indira Gandhi assassination case. AIR 1988, Supreme Court 1883, there is a total prohibition. Okay. Now we see Section 145 is centered on or centered around the previous statements. The term previous statements. The term previous statement presupposes existence of two statements and given at different points of time. Unless they are given, unless there are two statements which were given at different points of time, there cannot be, one cannot be called a previous statement. This can be seen from Section 145. The section says that the statement dealt with in it should be previous to the statement made by the witness in the witness box. So the previous statement should be understood in relation to the statement given in the witness box. And if there is no statement made in the witness box, there is no question of previous statement under Section 145. So the witness should have given a statement in the witness box, which we can call the primary statement. That is in this Tahsildar Singh's case, that particular time is used, the primary statement. But it can be called a subsequent statement because there are two statements, or better we can call it a present statement. So the present statement is the statement given by the witness in the witness box. This present statement, you see it is used in AR 1999 Supreme Court 3544. That appears to be the proper term, I think. Present statement. So in one case, there may be several previous statements. Each one may be used for contradiction under Section 145. The section does not say when and before whom the previous statement should be made. The section does not say. The section is silent about it. What does it mean? It means it can be any previous statement. It can be a statement before the court, statement before the police, statement to a friend, statement to a stranger, or anything. So pleadings filed in courts, depositions in judicial proceedings, statements before police under Section 161, then letters written to anyone, they are all examples. Previous statement may be said to be a statement made by the witness outside the witness box in the case in which Section 145 is sought to be invoked. It is sufficient. It appears that it was made at a point of time prior to the statement made in the witness box. So from the section, it appears that it is sufficient that the previous statement was made at a point of time prior to the making of the statement in the witness box. So it can be just before this testimony. It can be years before this testimony. There is no difference. It can be before any person. But we can see a different view taken by the Supreme Court, which appears to be very strange. This view is expressed in State of NCT of Delhi versus Mukesh. That is 2014, Volume 15, SEC 661. It is a 3-judge bench decision. The Apex Court has held that a statement made after the final report is filed does not qualify as a previous statement for the purpose of section 145, which appears to be very strange. In that case, the previous statement was allegedly made in this Mukesh case. The previous statement was allegedly made in an interview, in a television interview. This statement was sought to be produced before the court, or the witness was sought to be contradicted with the statement given in this interview. The Supreme Court held that that interview was given after the final report is filed, but certainly before this witness was examined. The Supreme Court that as it was filed after the final report was filed, it does not come under section 145. The reason stated by the Supreme Court is that in Tahsildar's case, there is such an observation. See, the Tahsildar says actually what was the statement which, what was the statement that was in controversy? It was a statement under section 161. That's why the Supreme Court said that any statement given to the police under section 61, which can be only before final report is filed, he only qualifies for previous statement under section 145. That is the reason the Supreme Court in Tahsildar says did not examine whether any other statement is qualified to be called the previous statement under section 145. And it is well settled that any other statement before any authority, made before any authority, can be a previous statement for the purpose of section 145. So the view expressed in this Mukesh case, in my view, does not appear to be correct. Okay, then can a subsequent statement, a statement subsequent to the examination of the witness, be relevant under section 145? The Supreme Court said no, it is not relevant because the witness was sought to be recalled. An order was sought to recall this witness to contradict him with a statement made subsequent to his examination. The Supreme Court said no. That is in 2005, volume 10, SEC 701. It has already been mentioned that section 145 does not say before whom or to whom the statement, the previous statement should be made. It can be before any person, it can be to any person. The statement should be in writing. The previous statement should be in writing or reduced in writing. We know the difference between in writing and reduced in. There may be four situations. One, take a case of letter. A letter in the handwriting of the witness, but not signed by him. It is in writing. He is the author. A letter in the handwriting of the witness and signed by him. Then third situation, like first information statement, or the statement recorded by the police and signed by the witness. Then statement given by the witness and in the handwriting of the police, but not signed by the witnesses. All these statements are previous statements for the purpose of section 145. It need not be signed by the witness. Then the next requirement is that when a witness is sought to be contradicted with a statement, previous statement, he should be the maker of the previous statement. One witness cannot be contradicted with the statement of another witness. So the maker of the previous statement should be the person who is in the witness box. This was all held by the Supreme Court in many decisions, one of which is AER 2004 Supreme Court 313. Then AER 2000 Supreme Court 185. There are other decisions also. Then another requirement is that, see what the section says. A witness may be cross-examined as to previous statements made by him in writing or reduced in writing and relevant to matters in question. So the statement should be relevant to the matters in question. Only such statements can be used under section 145, not any statement, though it may be contradictory. So the first question to be decided is whether the previous statement has any relevancy to the matters in question. That's the first question to be answered. Then, when we come to section 145, it has two limbs. Section 140 has two limbs. Though section 145 deals with the cross-examination of witness, it has two limbs. Whether the second limb has any application depends upon the result of the cross-examination in the first limb. So whether the second limb is applicable or not depends upon the answer given by the witness in the first stage of the first limb of the cross-examination. So let us see how it happens. The first situation, witness admits the previous statement. Witness admits the previous statement. The cross-examination, that is the first stage. You are cross-examining, the advocate is cross-examining the witness as to the previous statement. The cross-examination may result in one of the following two situations. One, the witness admits having made the previous statement attributed to him. Yes, I made that statement. Okay. Then, if the witness admits the previous statement, the section has no further application. That is the end of it. The second limb cannot be invoked, or there is no opportunity of the second limb being invoked. The court has to only record that admission and nothing more. No other formality is to be, no other procedure is to be complied with. That is, the Supreme Court has held it in Tahsildar Singh versus State of UP, AR 1959, Supreme Court 1012. Again clarified in AR 1997, Supreme Court 322. But there is a different opinion expressed by a learned single judge of the Kerala High Court recently. That is in Bhima Jewelers and Diamonds Private Limited versus Sandeep Kumar, 2020, Volume 5, KHC 550. The observation of the learned single judge is, when the witness admits the document, the court then will mark it, what? The document, the statement, and admit it in evidence subject to its relevance and probative value. That is per incurium, for more than one reason. One, it is the admission of the witness that proves the fact of the witness making the statement, and it is not the document. When that fact is admitted by the witness, Section 58's Evidence Act applies, and it need not be proved. And there is no question of marking the document to prove it. And that is against the Supreme Court decision also. The Supreme Court said that is the end of it. That admission is sufficient. And the second is that the witness may be cross-examined as to his previous statement. That is at the beginning itself, only if it is relevant. See, only if the court is satisfied that the previous statement sought to be invoked is relevant. I have already mentioned it. Then only the cross-examination can be allowed. So that's the first step. And the court has to decide the relevancy not later, as decided by the, as observed by the learned single judge. Okay. Then probative value has to be decided later. Probative value, what is the probative value? There is only one probative value we can discuss later. So to that extent, the decision of the Kerala High Court in this Bhima Jewelers appears to be wrong, erroneous it is. Then, the second situation, when witness denies, yes, I did not make such a statement, or does not admit the previous statement. Two situations. One, he denies it. The second, he does not admit the previous statement or having made the previous statement. He will say that I don't remember it. I don't remember it. That is not admission. So if it is not admitted, it falls under this head. Witness denies or does not admit the previous statement. So the question of the second stage arises only if the witness denies having made the statement or does not admit having made the statement. Only in that case, the second limb, the question of second limb, applying second limb arises. In the case of admission, the question of the second limb does not arise at all. So it is the stage of contradiction. So the stage of contradiction arises, or that is the second limb. It arises only when the witness denies or does not admit the previous statement. Otherwise, there is no question of the second limb being invoked. There is no contradiction at all. The reason is simple, because he has admitted the contradictory statements. Then, so a witness who has admitted the contradictory statement, contradiction, need not be contradicted. Need not be contradicted. That's why the second limb is not applicable when the admission is made by the witness. Okay. Now we shall come to the meaning contradiction. Contradiction. To contradict means to affirm to the contrary. That is the Oxford English Dictionary. That is referred to in this Tahsildar is also celebrated decision. Six-judge bench. Then, what amounts to contradiction? What amounts to contradiction? The meaning we have seen, the literal meaning we have seen, it amounts to affirm a thing to the contrary. So, contradictory statements are necessarily inconsistent. Contradictory statements are necessarily inconsistent. But all inconsistent statements cannot be used for contradiction. Only when both statements cannot coexist, they become contradictory. Only when the two statements cannot stand together, cannot coexist, there is contradiction. That is the decision of the six-judge bench observation in AR 1959, Supreme Court 1012 Tahsildar's case. Then AR 1999, Supreme Court 3544. And in this 1999 Supreme Court, His Lordship Justice K.T. Thomas examined the meaning of it. And this is the observation in that decision. A former statement, though seemingly inconsistent with the evidence, need not necessarily be sufficient to amount to contradiction. So it appears to be contradictory statement, but it need not be contradictory. It is inconsistent, maybe inconsistent, still it may not be contradictory. AR 1999 Supreme Court 3554. Unless the former statement has the potency to discredit the present statement, even if the latter is at variance with the former, to some extent, it would not be helpful to contradict the witness. This is the observation of the Supreme Court in this Ami's case. So, we can have some illustrations. See, the witness, who is a young girl, deposes, said to the police under section 161 CRPC, the accused wrote me several love letters. The accused wrote me several love letters. But in the witness box, she stated, the accused wrote me about 30 letters. We know that when two such statements are in, always, invariably in all cases, the advocate will cross-examine under section or use it under section 145. This will be contradicted, sought to be contradicted with that previous statement. See, here what happens? the witness did not state to the police the number of the love letters. But 30 love letters in the witness box, she says, that means several letters. So she has given more details in the witness box, or she is more specific in the witness box. That does not mean that they are inconsistent or contradictory. And it means that if the foundation is there in the previous statement, the subsequent statement, if there are some details, they do not amount to contradiction. They do not amount to contradiction. Now, the contradiction is not between what witness said, he had stated before the police, and what he actually stated before him. It should be between what he asserted in the witness box and what he stated before the police. So only two statements. What comparison should be made between the statement in the witness box and what the witness actually told the police, and not the witness now said in the book what I stated to the police. They are different. That is AR 1959 Supreme Court, again 1012. Again 1012, Sahsildar's case. So we have seen that, as we say in this matters of bail, we said that, or custody, we say under section 25, 26, and 27. In every arrest there is custody, but in every custody there is no arrest. Like that, every contradictory statements are always inconsistent, but all inconsistent statements are not necessarily contradiction. That is what the Supreme Court has held. Now, what's the purpose of contradiction? This should be understood properly, because we are considering not only section 145, 155 also, which our young advocates may not be able to understand properly. They look alike, contradiction under section 145 and 155. And the terms used by the Supreme Court and the High Courts in various judgments, they are also the same under section 145 and 155. So that has caused some confusion and people leave it there. Okay, the purpose of contradiction. The best has given the purpose of contradiction in this book. There are two purposes. The purpose is twofold. One, to show the faultiness of the memory of the witness. Two, to impeach the veracity of the witness. That is credit. So they are distinct. Suppose a person gives a contradictory statement in the witness box with regard to a particular fact. It may be due to various reasons. It may be because of loss of memory, one of the reasons. So that will not empower the court to dub his testimony as false, the entire testimony as false. This was quoted in AR 1976 Supreme Court 294. 294. So there are two purposes. They are not one and the same. And we can say that, to be more specific, we can say that one purpose is fact-oriented. The second is the credit of the witness oriented. Credit-oriented. The first is the fact-oriented. The second is the credit-oriented. We shall see the meaning of it later. Okay. What is the effect of contradiction? Even if a witness is contradicted, his testimony may be accepted. There is no law to the effect that once a witness is contradicted under section 145, no, there is no such law. And the Supreme Court has stated it. Even if a witness is contradicted, his testimony may be accepted if it is corroborated by other reliable evidence. If it is corroborated by other reliable evidence. That is Bhagwan Singh versus the state of Haryana. AER 1952 Supreme Court 214. And again, the Supreme Court says the contradiction will be considered along with the evidence to the worth of the witness in determining his veracity. AER 1971 Supreme Court 1910. It means that it will only make a part of his evidence unreliable. So the effect of contradiction depends upon the nature of contradiction. The effect of contradiction depends upon the nature of contradiction. All contradictions are not of the same nature. Sometimes it will only discredit a part of his testimony or cast doubt upon a part of his evidence. That does not mean that his entire evidence is false. And we cannot say which one is false also. And what is the effect of such contradiction? If the contradiction is with regard to a particular fact, that means he has given two contradictory statements with regard to a particular fact. That means his evidence as to that fact cannot be acted upon. His evidence as to that fact cannot be acted upon. That's all. That's why the Supreme Court said that if the version in the witness box is supported by other reliable evidence, it can be acted upon, notwithstanding the contradictory statement, previous statements. So we cannot throw away the evidence in its entirety. That is what the Supreme Court has said.
Now, sir, one suggestion from the attendees. So when you are citing the decisions, so that it should be cited slowly so that they can write it down.
Oh,
that is there.
Sorry.
Thank you.
That is AER 1971 Supreme Court 1910. AER 1971 Supreme Court 1910. The contradiction will be considered along with the evidence to assess the worth of the witness in determining his veracity. So its worth has to be decided later. It cannot be thrown out. Then the effect of contradiction depends upon the nature of contradiction. It may only discredit a part of his testimony, and that part can be ignored. That part alone can be ignored. His entire evidence cannot be ignored. His evidence as to the other facts may be acted upon if it is reliable. That means a part can be accepted, a part can be rejected. That is the theory behind it. Now, but there may be cases where the contradiction will destroy the entire evidence of the witness. The evidence of the witness in its entirety will be destroyed. That means he is totally discredited because of the nature of the contradiction. Take a case where the witness deposed before the court. I witnessed the incident which took place in Kochi. That is his previous statement. Sorry, that is his present statement in the witness box. But it is proved that he had written a letter to a friend to the effect that at the relevant time, he was in Chennai. What does it mean? He had no opportunity to witness the incident at all. That means his entire evidence is liable to be ignored because no sentence, no part of it can be acted upon. That is actually destruction of the entire evidence. Actually, then, see if such a contradiction is brought out under section 145, what happens? Clause 3 of section 155 becomes applicable. That is, his credit is impeached. The term used there under section 155 is a impeachment of credit. If a credit of a witness is impeached, not even a single part of his evidence can be acted upon. Not even a single sentence can be acted upon. That is the difference between these contradictions. It depends upon the effect of the contradiction, depends upon the nature of the contradiction, whether that particular fact is liable to be ignored, whether the entire evidence is liable to be ignored. That we have to decide. Then such contradictions which destroy the foundation of his evidence, the foundation of his evidence falls under clause 3 of section 155, which we shall consider later in detail. Now, what is the procedure for contradiction? Everybody knows it. The procedure. The procedure for contradiction is given in the second limb of the section. The second limb contains the procedure. Merely because the witness does not admit or the witness denies having made the statement, the second limb does not become applicable. Mere denial. The second limb is not applicable. Then what is necessary for its application? It applies only if the cross-examiner intends to discredit him. Suppose the cross-examiner is satisfied with the denial. Okay, nothing to be done. No contradiction. Again, that is the end of the section 145. But he wants to discredit the witness or his part of his testimony by contradicting him. Then the procedure prescribed in the second limb of section 145 shall be followed. It means that there is no question of following the procedure prescribed in the second limb of section 145, where a witness admits the previous statement. So if the witness admits the previous statement, then the procedure prescribed in the second limb of section 145 has no application. That's why I told you earlier that when admission is made, that is the end of it. That is the end of it. Nothing to be done. No marking, nothing. Okay. Under section 145, the second limb, the witness should be given an opportunity. First, his attention should be brought to the contradictory statement attributed to him. The second is, he should be given an opportunity to explain it. In practice, actually what happens? The witness will be asked, did you make such a statement when you were examined under section 161 by the police? No, he will deny. Then the next question is, it is seen recorded that you made such a statement to the police. That particular statement should be put to the witness. It should be reproduced verbatim. There is no question of paraphrasing it. It should be put to the witness verbatim. And he should be asked what explanation he has to give. Then only this contradiction becomes complete, but for one step, which is to be done later. The section says that the witness may be contradicted even if it is not proved. See, we have already seen it. Proof comes later. So even if it is not proved, the contradiction has to be made. This does not mean that the proof may be, it does not mean that proof need not be given at all or need not be proved. It only means that proof may be given later. And that is the last step. That is the last step under section 145. The making of the statement, contradictory previous statement, shall be proved through a person who is competent to prove it. If it is a statement recorded by another person, that person should be examined as a witness. That's actually what we do when we examine the police officer who recorded the statement under section 161. And that question should be put to the, and should be brought out through that witness, that the witness made such a statement. And if that is not done, if that last step is not done, contradiction is not complete and it becomes a useless exercise. And the important decisions, we can see the first one is Tahsildar's case, AER 1959, Supreme Court 1012, how to contradict a witness. Then 1997, Volume 1 SEC 283, 1997, Volume 1 SEC 283, 2003, Volume 12 SEC 587, then 2015, Volume 9 SEC 588. So the examination of the person who recorded the statement is necessary to prove the document. And if it is not brought out through that witness, there is no proof of this witness making the contradictory statement. Now, what is the practice? What is the practice when a contradictory statement is put to the witness? The practice is to mark that particular portion, in the document. It serves two purposes. One, it satisfies the requirement in section 145 that the previous statement should be in writing. So the court is satisfied that it is in writing. The second is that it reminds the court. That it has been marked but not proved. How it is to be done? The practice is to mark that particular portion subject to proof. It reminds the court that it has not been proved so far, it is yet to be proved, though it has been used. Though this statement has been used to contradict the witness in the section 145, it has not been proved, it is yet to be proved. It is a reminder to the court. That is, that practice has been noted by the Supreme Court in Tahsildar's case, AER 1959, Supreme Court 1012. In one case, the court suo motu contradicted the witness with a previous statement recorded by a person. But the court did not, or nobody examined the person who recorded the statement. The Supreme Court held that it is not legal, even if it is invoked by the court. Say under section 165 CRP, 165 Evidence Act, the court power is there. Okay, then it has to be proved. It is necessary for the prosecution or the court to prove that the witness made such a statement. If that is not done, merely because the contradiction was brought out by the court, section 145 is not complied with. That is V.K. Misra's case, that is in 2015, Volume 9 SEC 588. This does not say that court has no power suo motu to contradict the witness. It only says that if it is not proved, it is of no use. To that extent only, it can be relied on. Then, the whole statement of the witness, suppose the portion sought to be contradicted, the statement sought to be contradicted is only a part of a document. Then what should be put to the witness? The whole statement should not be put to the witness. Only that part which is contradictory should be put to the witness. and suppose the whole statement happens to be what is its effect? The Supreme Court held that the question there is whether it has caused prejudice to the accused. If it has caused prejudice to the accused, that procedure cannot be accepted. But if it has not caused any prejudice to the accused, then it has only to be ignored. That violation has only to be ignored. That is AR 1968, Supreme Court Digest, SED 790. That is Ramesh Chandra versus State of Maharashtra. Ramesh Chandra versus State of Maharashtra. I don't know whether it is reported in any other journal. Then we have seen the procedure to be followed. The procedure to be followed, we have seen the requirements of section 145. One is that the previous statement should be in right. It is available only during the cross-examination. The second is that it should be in writing. The third is that it is relevant. Then the fourth is that it is brought to the notice of the witness. Then fifth is that he should be given the opportunity to explain it. And the last one is that the statement should be proved through the person who recorded it. See, suppose the attention was drawn to the witness, but it was not put to the witness, or it was not, he was not asked what explanation you have to give. What explanation you have to give for this contradictory statement? Then that is not fatal. Substantial compliance is sufficient. Substantial compliance with the procedure prescribed to section 145 is sufficient. That is Bhagavan Singh versus State of Haryana, we have already seen. AR 1952 Supreme Court 214. Because once this part of this statement is brought to his notice, it is understood that it is asked for his explanation. Then, what is the effect of non-compliance with the procedure? What is the effect of non-compliance with the procedure? If the procedure prescribed by the second limb of section 145 is not complied with, the evidence of the witness as to that fact becomes unassailable. That means the court will act upon it. If the procedure prescribed by section 145, the second limb of section 145 is not complied with, the result is that the court can act upon that evidence. That is AR 1971 Supreme Court 1910. 1910. Then, so we have seen what a contradiction is. All inconsistent statements are not contradictory. Only those statements which cannot exist simultaneously, they can be only such statements are contradictory statements for the purpose of section 145. Then the purpose of contradiction twofold: one, to discredit the witness as to a particular fact, or to discredit the witness in entirety. These are the two purposes. Now, whether omission will amount to contradiction. Omission will amount to contradiction is the next question. This question arose before the Supreme Court in several judgments. The first one is the celebrated decision of Tahsildar Singh's case, AR 1959 Supreme Court 1012. So the word omission does not find a place in section 145 or any other section. Omission or 155 it is not seen. The question whether omission amounts to contradiction was considered elaborately in AR 1959 Supreme Court 1012 in Tahsildar's case. The six-judge bench first considered the meaning of statement. The meaning of statement. The ordinary or literal meaning is that what is stated or recited. What is stated or recited. The Supreme Court said that a statement cannot include that which is not stated. There cannot be any controversy about it. When something is not stated, we cannot say that it is a statement. But the court held that a statement includes not only what is expressly stated, but also what is necessarily implied therefrom. This is the observation of the Supreme Court. But very often, to make a statement sensible or self-consistent, it becomes necessary to imply words which are not actually in the statement. Though something is not expressly stated, it is necessarily implied from what is directly or expressly stated. And the court has put forward the theory of deemed statements. Deemed statements. So in the case of omission, there is a deemed statement. And there may be three situations. When we consider the question of omission, three situations can be seen. One, sometimes some words have to be supplied. We have to add some words to the statement expressly made by the witness. That is, we are adding something to the statement because it is implied there. Illustration. I saw the witness, the illustration, witness said, I saw accused stab Z to death. This is the statement to the police. What is the statement? I saw accused stab Z to death. But in the witness box, he says, I saw both accused. There are two accused, A and B, stab Z to death. Does it mean that merely because he mentioned only the name of A in his previous statement, does it mean that he did not say that B is not B did not stab him? That's the question. The Supreme Court said in such a statement, it should be read as I saw accused A only stab is to death. We have to supply that word only. That word only shall be supplied. We should add to it because it is understood. That is the first situation. We are supplying some words. The second situation, sometimes a negative or a negative aspect has a positive aspect. Negative statement has a positive aspect, and a positive statement has a negative aspect. Illustration. A states to the police, the culprit was a boy. It implies that the culprit was not the culprit was not a girl. So it is a positive statement, but it has a negative statement, negative aspect. When a person says that that person was a boy, it means that he was not that person was not a girl. So that is implied there. Then A states The culprit was not an Indian. The culprit was not an Indian. It is implied that he was a foreigner. So negative statement, positive aspect. Positive statement, negative aspects. This is possible. Then the third situation is direct contradiction. That is, two statements cannot coexist because of inherent repugnancy. One must be false if the other is true. A says to police, I saw R stabbing S to death. But he deposed in court, I saw R beating S to death. The Supreme Court in Tahsildar Singh case observed these three situations were visualized by the Supreme Court. These illustrations have been given in the judgment, and then the Supreme Court, as the Supreme Court was observed. The doctrine of there are three situations we have considered now. The doctrine of recital by necessary implication. That is situation one where we supply some words. Then the second, the concept of negative or positive aspect of the same statement, recital. That is the second situation. Then the third one, the principle of inherent repugnancy. That is the third situation. May, in one sense, rest on omission. But by construction, the said omissions must be deemed to be part of the statement in writing. Such omissions are not really omissions, strictly so-called, and the statement must be deemed to contain them by implication. A statement, therefore, in our view, not only includes what is expressly stated therein, but also what is necessary implies therefrom. Paragraph 18 of this Tahsildar Singh's case. The fiction, but the Supreme Court cautions, the fiction of deemed statement is permitted only in the above three situations. The fiction of deemed statements with regard to omissions is permitted only in the above three situations, because that is the test. So for us, there is a test. Whether it is covered by any of the three situations. If not covered, okay, it is not an omission for the purpose of section 145. And omissions may or may not amount to contradiction. Only those omissions which amount to contradiction are covered by section 145. That is AR 1982 Supreme Court. AR 1982 Supreme Court 839. Now we are coming to the effect of omission. We have seen the effect of contradiction, similar, same, identical. The Supreme Court also held it's not possible to lay down a general rule as to the effect of a particular omission. The effect will depend upon the totality of the proved facts and circumstances. It has to be considered as a whole. The evidence has to be considered as a whole. That is AR 1974 Supreme Court 408. Now I think we can leave the remaining part to the second class or second seminar.
Yes. Yes, sir, we can. I just wanted to add one aspect in Tahsildar Singh's. It is an interesting fact. In fact, in Tahsildar Singh's case, what happened was the witnesses were asked, did you say before the police officer that you saw a gas light? In fact, the incident happened during night. So before the police, they never said that there was a gas light. That was omitted. But in the deposition, it was stated that there was a gas light and they saw in the gas light. The question was, did you tell the police that there was gas light? The Supreme Court held that it does not amount to, as Abraham Mathew said, right, does not amount to contradiction. And that question you cannot put to the witness. So this is what our trial lawyers and judges should remember. What amounts to contradiction? Now, sir, there are some questions by attendees. Shall
Yes.
I read out the questions? So that the first question is, does test identification parade come under the ambit of 162? Can we cross-examine on such statements? Now, during test identification parade, statements given to the police come under section 162 of the CRPC. You can, is it not, sir? Hello? Am I audible? Hello?
Yes, Hari, I can hear you.
The question is this.
Ah.
During test identification parade, some questions are being put. That is not the manner in which the question has been framed.
Yes.
Can we cross-examine the witness on such statements? I think there is a decision of the Supreme Court also on the point. AR 55. Sir.
See, I disagree with the opinion expressed by Mr. Hari because the test identification parade, who conducts?
Magistrate.
Magistrate. And from where the power flows? Only from section 164. So that is the only power given to the magistrate under the CRPC to take part in the investigation. Because test identification parade is conducted during investigation. It's a step in investigation. But it is not a statement made to the police. It is a statement made to the magistrate, judicial magistrate. So it is not.
No, the question is not that. Question is the statement given under section 162 CRPC. So actually the test identification parade is done by the magistrate. Any statement given to the magistrate is under section 164. But the question here is the statement given to the under section 162.
No, it's a statement given under section 164.
164. That can be used for contradiction as well as corroboration.
164 subsection 5. See, there are some statements made to the police. One is a dying declaration. Under what provision the magistrate conducts the dying declaration, records the dying declaration? It comes from section 164(5) only. Otherwise, how can you get the power?
Even under section 32 of the Evidence Act, the dying declaration given to the police officer is saved.
Right, that is true. Saved. But the magistrate gets that power only from section 164.
164 and also 35.
Same test identification period, same. But there is a stray observation by the Supreme Court that is under section 162.
That's what I said.
Wrong. That is wrong actually, because it is under section 164. My state takes part in this investigation.
Now there is it actually comes under section 157 when it is given to the magistrate during investigation. But 157, if you literally read it, it is given to the person investigating the offense or at or about the time when the offense has taken place.
Right.
So magistrate deemed to be conducting investigation under section 1.
Right. Limited.
So therefore,
limited role.
So therefore, what I am saying that it can be used for contradiction as well as corroboration.
For contradiction, section 145 or corroboration under section 145.
That is what I said. I did not say that it can't be used.
Right.
So then the next question is, does prior statements in writing include electronic documents also?
So we shall consider these questions in the next class, because I will be taking each of the statements. Many statements. There are many statements. Many statements come before the court. 161 statement is there. 154 statement is there. Then 164 statement is there. Mahasar is there. All this can be considered in the next class.
Next class. I will do one thing. I will forward these questions so that you can have a look at them. Thank you. Thank you, sir. Thank you for the edifying class. I have been sitting.
So
thank you very much. Thank you, Live Law.
We shall fix a date later.
Yes, sir. Subject to our convenience.
Okay. Thank you very much.
Thank you.